Justice Gorsuch tried to corner a young attorney in front of the entire Supreme Court, but when she calmly cited his own past opinion to prove him wrong, the whole room fell silent. The line outside the Supreme Court stretched around the block. It was just past 8 a.m., and already a bitter February wind swept through First Street NE in Washington, D.C. Inside, the courtroom was heating up, not just from the full benches and bright lights, but from the anticipation of a high-profile case that had captured national attention. Federal versus Miles, a constitutional challenge over the government's power to seize digital property under the Fifth Amendment. But while the legal question was huge, the real buzz was about who was arguing it. Not the government's lawyer, not the media pundits. It was Jasmine Crockett. She walked through security with quiet focus, slim black folder tucked under one arm, hair in a low bun, no flashy jewelry, no entourage, just her and her purpose. A few clerks whispered as she passed. A couple of the older attorneys squinted, trying to place her. Nobody really could. Jasmine wasn't a household name. She hadn't clerked for a justice or taught at an Ivy League law school. She was 38, came out of Howard, built her practice in St. Louis, representing folks who couldn't afford much more than a bus ticket and hope. But over the years, her filings started landing on the desks of bigger firms and eventually on the radar of civil rights watchdogs. When the Miles case was picked up, she filed a brief so sharp and unexpected that even the government had to recalibrate. Still, as she entered that courtroom, every eye measured her. The justices were already seated. Chief Justice Roberts leaned back slightly. Kagan was reviewing notes. Thomas, stoic as usual. And then there was Justice Neil Gorsuch, eyes locked on the docket sheet, flipping pages with a sort of idle amusement. The audience settled. Reporters, law students, clerks, all of them waiting for the same thing. Would this unknown defense attorney actually make a dent in a courtroom this intimidating? "Miss Crockett," Roberts called, "you may proceed." Jasmine stood, adjusted the microphone, and glanced briefly toward her client, Anthony Miles, a quiet 27-year-old who hadn't said a word all morning. He nodded slightly. It was the only nod she needed. She began clearly, "May it please the court," and then, without notes, without hesitation, she launched into her opening. The Constitution doesn't bend for convenience. When the government wants to take something, it must justify that action under the rule of law, not preference, not urgency, and certainly not software policy. Her voice was steady, conversational, not performative. She spoke like someone explaining something important to a room that had already made up its mind. She laid out the structure of her argument in 4 parts, then started with the first precedent. It wasn't flashy, but it was clean, tight, familiar. Citations, gritty interpretation. She was making her way up the mountain, brick by brick. But something was brewing in the front row. Gorsuch leaned his chair back just slightly, thumb resting on his temple. His eyes scanned her, calculating. She had barely started her 3rd paragraph when he cut in. "Counsel," he said, lifting an eyebrow, "are we truly going to lean on outdated jurisprudence from 1952 as a lens for digital asset seizures in 2025? A pause. Laughter rippled from the back row. Even Roberts cracked a faint smile. It wasn't just a challenge. It was a shot, one that said, "Nice try." Jasmine held the silence, let it settle, then calmly responded, "Yes, Your Honor, because the government's method of seizure today echoes the same constitutional flaws the court identified in United States versus Peoria, just dressed in newer code. And respectfully, the technology has evolved, but due process has not." That shut the laughter down. Still, Gorsuch wasn't finished with her. But Jasmine didn't come here for approval. She came to argue the law. The moment Jasmine opened her mouth, the room shifted, just not the way they expected. Gorsuch gave a half smile, the kind that didn't quite reach his eyes. "So we're going to pretend a Cold War-era opinion should define how we regulate cryptocurrency transfers and remote data access? That's an interesting leap." The courtroom chuckled again, a little louder this time. Jasmine stood still, hands lightly folded on the podium. She didn't flinch, didn't shift her weight, just listened, let them get it out of their system. Gorsuch went on, tapping the bench lightly with a pen. I think we both know there's a difference between physical grain silos and server farms in Nevada, Council. Another light laugh from the press gallery. It wasn't just skepticism, it was performance. Gorsuch knew the cameras were running. He had a reputation for throwing pointed lines, the kind that made it into law school lectures and legal Twitter threads. And Jasmine, she was being positioned as the foil. A lesser attorney might have gotten rattled, might have tried to rush into a response. Backpedal, overcorrect. Jasmine didn't. She took a breath and looked directly at him. "Justice Gorsuch," she said calmly. "I'm not pretending anything. I'm applying precedent. The question isn't whether the asset is grain or digital. It's whether the government followed a constitutional process before taking it." Peoria addressed the procedure. What we call the thing doesn't change what they failed to do. The room went quiet. She didn't raise her voice. She didn't try to impress. She just said it plainly, like it was obvious. And maybe it was. Gorsuch blinked, just once. His eyes narrowed. Not with anger, but calculation. She wasn't backing down. Sotomayor leaned forward a bit in her chair. Alito scribbled something quickly. Justice Jackson nodded subtly toward her law clerk. It didn't stop Gorsuch, though. He pivoted. "Let's assume for a moment your client's rights were violated under the Fifth. That still doesn't explain your use of Dunlap versus United States in your second brief. That ruling was reversed in part by this very court, was it not?" He was baiting her again. She knew it. Jasmine didn't blink. Reversed on the question of timing, not on the procedural standard of seizure. "I'm applying the part your concurrence didn't object to, sir." A few heads turned. Did she just correct him on his own concurrence? Yes, she did. She let that sit, then added, "And that procedural standard mirrors what the court affirmed in Garner versus Reed, a decision you authored in 2021. That's when the weight shifted. It was subtle, but you could feel it. The temperature in the room dropped a degree. The laughter was gone. Nobody dared smirk now. Jasmine wasn't just quoting precedent, she was referencing the court's current reasoning, using Gorsuch's own words, to make her case stronger, not to shame him, but to build something on top of what he had already laid. She wasn't performing, she was practicing law. A woman in the third row leaned forward, a professor from Michigan here to observe. She mouthed, "Wow." Jasmine moved forward in her argument. She didn't speed up, didn't slow down either. She walked. The court threw a timeline of the seizure, showing where the agencies acted outside the bounds of their warrant, then tied it back cleanly, directly to the same patterns condemned in 3 prior cases. She was methodical, and every word had weight. Her client, Anthony Miles, sat still as stone, but his eyes were locked on her. For the first time since he'd entered that building, something like hope started to show on his face. But what struck? People most wasn't just her command of the law, it was how little she seemed to need their approval. She wasn't there to be liked, she was there to be heard. But Jasmine doesn't blink. She's been underestimated her whole life. By the time Jasmine moved into her second major point, the violation of digital property rights without judicial review, the room had gone dead quiet. No more sarcastic chuckles, no sideways glances. What had started with smirks was now leaning into something else entirely. Attention. She spoke clearly, her cadence steady. What's dangerous here isn't just what was taken, but how. A password isn't just a string of characters. It's access, it's identity, it's a key to everything we once called private. Justice Kavanaugh interrupted. "Counsel, are you suggesting the seizure of a password is on the same level as a warrantless home entry?" Jasmine nodded. "Yes, Your Honor, because in 2025, seizing a password can yield more than a search of someone's physical house ever could. We used to keep diaries in drawers. Now entire lives are locked behind digital walls. If those walls can be bypassed without review, the Fourth and Fifth Amendments mean nothing." For a second, no one moved. Justice Sotomayor leaned forward, pen hovering. "And you argue this was done entirely outside the scope of judicial oversight?" "I don't argue it," Jasmine said. "I show it. Appendix B of the record includes time-stamped agency actions that occurred after the warrant expired and before the review hearing was scheduled. The seizure wasn't just sloppy, it was unconstitutional. That's when people started whispering again, but it wasn't doubt this time, it was recognition. She wasn't just making legal points. She was building an undeniable case, one brick at a time, without a single wasted sentence. Her command of both constitutional theory and real-world implication was unsettling the court in a way no one expected. From an attorney who walked in here with nothing but a folder and her voice. Justice Gorsuch sat back, hand on chin, now watching her in a different light. He had underestimated her, that much was clear. But Jasmine didn't care about that. Her focus stayed on the law, on her client, and on the record. She pulled up another citation, Bowman v. Tarrant County, 1994, a case that hadn't been cited in years. A few heads turned. That was deep legal benchwork, something you don't find unless you've read everything twice. Gorsuch asked, "You're invoking Bowman's separation of scope doctrine?" "I am," Jasmine said, "because that decision defines the limits of incidental discovery under a primary warrant, and in this case, the agency crossed that line by a mile." A long silence followed. Justice Barrett looked down, flipping through the printed brief. "That's not in the petitioner's argument," Jasmine answered, without missing a beat. "No, Your Honor, but the petitioner never had access to the unredacted seizure logs. We did, and when we reviewed them, we found 14 separate actions outside warrant scope. The math did the rest." Barrett stopped flipping. She looked up. "You did your homework." Jasmine didn't smile. "My client's liberty was on the line. I couldn't afford not to." The woman in the gallery from Michigan, the professor, was now scribbling furiously in a notepad. Behind her, a Yale law student looked visibly shaken. This wasn't what anyone expected. They came to watch an overconfident defense lawyer walk face first into the wall of federal power. They came for a train wreck. They were getting something else entirely. And Jasmine wasn't even sweating. She ended her segment with this: "The constitutional protections we cite aren't nostalgic. They're promises. If those promises only apply to analog lives and not digital ones, then they aren't protections at all. They're museum pieces." Gorsuch looked away for the first time in 15 minutes. Justice Jackson smiled, not at Jasmine, but at the room, because everybody felt it now. This wasn't just a good argument, it was something rare. A reminder that sometimes the sharpest mind in the room isn't the loudest one, and brilliance can look a lot like quiet certainty, but the biggest shift hasn't happened yet. It's what comes after that no one expected. It started small, a few rows back. A law clerk tapped her pen twice against her notepad, whispering to the colleague beside her. One seat over, a journalist from Minnesota, sent here to cover the government's position, silently flipped her press badge over, no longer scribbling quotes, just listening now. Then came the hum of shifting posture, subtle changes in the way people were sitting, less folded arms, more attention. Even the security guard near the door, who'd spent most hearings eyeing the room for disruptions, now stared straight ahead, eyes locked on Jasmine Crockett. She wasn't doing anything flashy, no theatrics, no shouting or overreaching, just a calm, methodical demolition of the prosecution's claim, one legal citation at a time. She didn't lean too hard on emotion. She let the facts speak and the silence in the room say the rest. Then came the questions. Real ones. Not jabs, not tricks to throw her off. Justice Kagan broke the pattern with a thoughtful tone. "Miss Crockett, how would you distinguish this digital seizure from the framework outlined in Holloway v. United States?" Jasmine, without pause. "That case involved consent obtained under coercive conditions. The issue here isn't consent, it's circumvention. The agency skipped both consent and review entirely, which moves us out of Holloway's shadow." Sotomayor jumped in next. "You're suggesting the agency interpreted the warrant with a level of discretion far beyond judicial intent?" "Yes," Jasmine said, "and in doing so, they created a legal black hole, one the Constitution never authorized." There was something in her voice, a quiet resolve that didn't beg for attention. It commanded it, like she wasn't asking the court to be on her side. She was showing them where the law already stood. From the gallery, even Anthony Miles, the quiet, reserved client she was defending, seemed visibly changed. He sat straighter now. His hands, once folded tight on his lap, rested open for the first time. He looked like someone who believed he might actually walk out of this courtroom with his future intact. The justices started taking more notes, not scribbles, long, thoughtful writing. Then Justice Gorsuch re-entered. He cleared his throat lightly. Mrs. Crockett, you referenced Garner versus Reed earlier. I'd like you to walk us through how you view its limitations in the digital context. There was no sarcasm this time, no theatrical pause, just a request. She glanced briefly at her notes but answered mostly from memory. Garner established a threshold for digital evidence seizure tied to authentication and intent. What this case shows is that when that threshold isn't met, the risk of government overreach becomes not just theoretical, it becomes systemic. Gorsuch leaned back in his chair. No quip followed, no commentary, just a quiet, "Thank you." That two-word response didn't seem like much, but everyone felt it. It was a shift from sparring to listening. Meanwhile, outside the courtroom, snippets of the hearing were already making their way online. The audio feed, broadcast with a 10-second delay, was being clipped by independent journalists. One video had already hit 10,000 views before the hearing even wrapped. In Tulsa, a second-year law student named Brianna watched it on her cracked tablet between classes. Her mouth opened slightly as Jasmine responded to Gorsuch. "She didn't even flinch," Brianna whispered, then hit replay. Back in D.C., Jasmine kept her rhythm. She tied the digital rights argument to a broader constitutional trend, the growing gap between evolving technology and rigid interpretations. She didn't claim to have all the answers, but she made one thing brutally clear. If the court allowed this seizure to stand, it would open the door to unchecked access over every encrypted space in America. A lawyer 2 rows behind the bench, one who hadn't spoken a word all morning, quietly exhaled and said under his breath, "She's changing the room." She was. Jasmine Crockett had walked in as the unknown, the long shot, a courtroom formality before the justices picked apart her argument. But she wasn't folding, she was leading. But Crockett's calm under fire is about to lead to a moment that silences even the most skeptical. The courtroom had settled into something rarely felt in such a high-stakes setting. Quiet respect, the kind that didn't need to be announced. You could feel it in the way pens moved slower across notepads, in the way questions were asked with less challenge and more curiosity. Jasmine was in full control of her narrative now, not dominating, not bulldozing, commanding, like a conductor, bringing an orchestra into focus. She took them through her final section, the human impact. For all the legal theory and structure, she said, this case is still about a man who lost access to his life without due process. Not just his files, not just his finances, his memories, his work, his voice online, and none of it was restored. She looked directly at the bench. No anger, just truth. Then, as if by cue, Justice Gorsuch adjusted in his seat. His voice cut through the stillness. "Counsel, let me return to your earlier point about Garner v. Reed. You cited that decision in the context of evolving standards for authentication, but that was a 2021 case. How do you suggest we interpret its boundaries now, in an age when digital identity is fragmented across multiple platforms and servers?" Jasmine met his eyes. No smile, no hesitation. "By updating the framework, not by abandoning the foundation," she said. "The Constitution was built to flex around change, but not to fold under pressure. What we're seeing isn't a failure of the document, it's a failure of the systems charged with applying it." Gorsuch went still, and then he did something no one expected. He leaned forward, fingers pressed together. "That's a compelling interpretation, counsel." A few murmurs rose from the gallery before Roberts cut them off with a look. Silence returned, but it was heavy now with meaning, not mockery. In the back row, Anthony Miles lowered his head, not out of shame, but out of something closer to disbelief, maybe relief. For the first time in 2 years, someone from the system he feared had just acknowledged his story. Jasmine continued, her voice softer now but just as steady. We talk a lot about original intent, but intent means nothing if it isn't applied with relevance. A modern seizure executed under ancient logic isn't constitutional fidelity, it's negligence in disguise. The statement landed hard. Justice Barrett scribbled a note, paused, then circled it twice. Gorsuch, still seated forward, tapped his finger once on the bench. You're not arguing that the Constitution changes. You're arguing the court must remain fluent in the world it governs. Yes, Jasmine said simply. He said nothing back. He just looked at her for a long, quiet second, as if seeing her argument now as a full working machine. Not just a collection of points, but a living, breathing thing built from logic, fueled by history, anchored in law. The silence in the room became its own kind of testimony. Jasmine didn't fill it. She respected it. Let the justices sit with her words. Then gently, she turned to her closing. Digital property, like physical property, exists under the same constitutional umbrella. And if we allow unlawful access, today under the comfort of new tools, we'll face the same old abuse with updated packaging. My client deserves more. The law demands more. She thanked the court, stepped back, and for a full 10 seconds, no one moved. Then Gorsuch spoke. Thank you, counsel. That will be all for now. It wasn't what he said. It was how he said it. No sarcasm, no bite, just acknowledgement. The professor in the gallery stopped taking notes. The clerk near the edge leaned back, visibly stunned. Even Roberts gave a barely perceptible nod, not toward the room, but toward Jasmine herself. This wasn't a victory, not yet, but it was respect, public, earned. But what happens outside the courtroom is what makes this story unforgettable. The moment Jasmine exited the courthouse, the cold air hit her like a second cross-examination. Flashes from cameras snapped in rapid succession, voices collided, and reporters surrounded her like they just spotted a celebrity. But her expression didn't change. Same calm eyes, same unhurried steps. She tucked a piece of hair behind her ear and kept moving. Miss Crockett, how do you feel about Justice Gorsuch's comments? Were you expecting that reaction from the bench? Will you be speaking at law schools, giving interviews? She didn't stop. She didn't need to. One hand gently rested on her client's shoulder, guiding him forward down the courthouse steps. Anthony Miles looked dazed, like he couldn't believe the weight he'd been carrying for years had finally been recognized, if only in part. They reached the sidewalk, and a young journalist broke through the crowd, holding out her phone like a microphone. Miss Crockett, can we just get one quote for the students watching online? Jasmine turned to her, just one sentence. I'm not here to be impressive. I'm here to hold power accountable. And with that, she disappeared into a waiting car. Across the country, the clip of that single moment, Gorsuch calling her argument compelling, hit millions of views in less than 12 hours. The exchange was looped, captioned, debated. Legal blogs scrambled to analyze her citations. Activist circles shared her closing words as a quote to be remembered. She had come into that courtroom a name barely known beyond her city and left it a national symbol of unexpected brilliance. But Jasmine never posted a thing. She didn't celebrate while others rode the high. She went home, slept, then called her client the next morning just to check in. You okay? She asked. He was quiet. Then he said, they listened. That was enough for her. Meanwhile, in places she didn't even know existed, things were already changing. In a high school in Boise, a history teacher replayed the hearing for a room full of seniors. They watched Jasmine stand her ground, quiet and confident. One girl in the back raised her hand after it ended. So she wasn't even famous or anything. Before this? No, the teacher answered. She just did the work. In a student union in Madison, 2 law students debated Jasmine's use of Bowman versus Tarrant County over a bowl of cold cereal. One of them pulled up her brief on a tablet and said, We've been looking at the wrong people to model ourselves after. In Los Angeles, a nonprofit that worked on digital rights and privacy sent her a private message. We've been in this fight for years. Watching you argue it like that, we're rethinking everything we do. Thank you. And in Tulsa, Brianna, the law. Student who watched it all unfold between classes, sat in her university library, earphones in, replaying the clip again. She copied a few of Jasmine's phrases down, word for word. Later that week, she brought them into a mock trial, used them during her argument, and scored her first real courtroom win. None of this was Jasmine's goal. She didn't chase the spotlight. She never tailored her voice to go viral. But truth has a way of traveling, with or without permission. Back in D.C., Anthony Miles waited outside the legal clinic where Jasmine volunteered twice a month. She told him she'd help him set up the next steps: privacy restoration, digital cleanup, a new job application. She arrived late, hair pulled back, coffee in hand. "Let's get started," she said. He looked at her, confused. "You still volunteer? Here after all that?" She smiled for the first time in days. "This is where people get missed," she said. "This is where law matters most." But Jasmine doesn't want applause. She wants the system to finally look like the people it claims to protect. Late that night, long after the courthouse emptied and the headlines had spun their cycle, a quiet room inside the Supreme Court remained lit. Justice Neil Gorsuch sat alone in his chambers, his glasses tilted slightly down as he flipped through a printed copy of Jasmine Crockett's brief. The same brief he'd once skimmed with amusement. But now he was reading every word slowly, carefully. A yellow pencil marked the margins, circling references he hadn't expected, notes in the footnotes that mirrored lines from his own opinions. Her logic wasn't just tight, it was surgical. He didn't say anything out loud. There was no one to hear it anyway. But there was something in the way he turned those pages. Deliberate, thoughtful. He wasn't just reviewing her argument. He was reconsidering his assumptions. Meanwhile, a few miles away in a modest apartment in Anacostia, Jasmine sat barefoot on her couch, laptop open, scrolling through emails. Most she didn't answer. Some were from press outlets, others from law. Professors wanting to quote her in upcoming lectures, a couple from young attorneys asking for mentorship. She clicked on one from a single mother in Missouri. "I watched you speak and I cried. My daughter's been afraid to study law because she thought no one would take her seriously, but you showed her otherwise. Thank you." Jasmine leaned back, resting the laptop on her thighs. She stared at the ceiling for a second, no smile, just a long breath. That's what she'd wanted all along, not attention, not praise, but proof. Proof that being excellent quietly, consistently, unapologetically was enough to change something. She walked into that courtroom with no nameplate, no law firm behind her, no secret handshake into elite legal circles, just her record, her preparation, and the belief that clarity matters more than credentials. And in doing that, she did something rare in American life. She made a room full of power listen. Really listen to someone they never expected to respect. She didn't do it by yelling. She didn't do it by trying to outplay anyone's ego. She did it by knowing her stuff better than anyone else in the room. Weeks later, law school forums were still dissecting the hearing. Some pointed to how she used precedent to turn a corner on digital rights. Others highlighted how she'd controlled tone, pace, and presence like a litigator twice her age. But the clip that stayed in people's heads, the one that replayed across classrooms, seminars, and dinner tables, was the moment Justice Gorsuch paused, leaned forward, and said, "That's a compelling interpretation, counsel." It wasn't just a compliment. It was the sound of someone realizing they'd misjudged a mind. And it made people everywhere stop and think about how often we do the same, how often we decide who's worth listening to based on how someone looks, or where they went to school, or how polished their voice sounds. In a courtroom full of tradition, brilliance doesn't always come wearing the badge of prestige. Sometimes it walks in quietly, speaks clearly, leaves with the truth intact. In Kansas City, a teacher hung Jasmine's courtroom quote on her chalkboard. "I'm not here to be impressive. I'm here to hold power accountable." Her students read it each morning. In Raleigh, a public defender borrowed lines from Jasmine's closing to defend a young man whose phone had been searched without a warrant. And in Baltimore, a girl named Simone, barely 12 years old, watched the video of Jasmine's argument on her grandmother's cracked tablet. When it ended, she turned and said, "I want to be like her." Her grandmother nodded. "Then start learning." That's how she did it. We should never mistake quiet for unqualified, never confuse calm for weakness, and never assume brilliance looks a certain way. Subscribe if you believe voices like Jasmine's deserve more than applause. They deserve a seat at the table.